Welcome to the Foul Play YouTube channel. Open mic number 189, and we are going to be going into Zellner's amended brief to the Court of Appeals. Bit of a surprise for me today. I think it was for the YouTube, probably everyone. I know it was for Susan because we were talking just a minute ago, and I wasn't expecting this at all. So we're not going to dilly-dally too much around here. I'm going to say I have Susan, Cherie, Kay, and Neverly on panel. Doc said he's going to try to join us. I'm not sure who else might try to jump in. I do need to share this here, though, in case anybody wants to jump in. Just a second. Okay, that's there. Anyway, this brief is it's 45 pages in all. So she's and she made a tweet or an X, whatever you want to call it these days. So a pretty snarky remark. Susan read it to me a minute ago. I hadn't had a chance to even get on X. Read it, Susan.
Yeah, let me find it again. There it is. She said, our newest brief on Avery filed today, posted on our website. Wisconsin needs the truth delivered in as few words as possible, apparently. 3 exclamation points. Glad to comply! Exclamation point.
She's the queen of those.
Yes.
Yeah, it's pretty good, pretty snarky, but pretty good remark. So anyway, we're not gonna mess around. We're gonna get right into this. Hopefully, it's gonna take us roughly an hour to read it, depending on how many times we stop. Zoom that in a little bit. So Susan, if you'd like to start us off on this journey of this corrected brief, you tell me where you're gonna start, and I'll get to it.
Okay, I'll just start on page 5, issues presented. That's the beginning of it.
There we go. I think I'm on page 5.
Okay.
Introduction. Is that where you're at? Oh no. There it is. I'm sorry.
Okay.
I went down too far. Yeah, I got it.
Okay. Issues presented. 1. Whether the circuit court improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of State v. Edmonds and Brady v. Maryland. The circuit court answered no. 2. Whether the circuit court erred when it did not correctly apply State v. Denny to Mr. Avery's potential third-party suspect evidence. The circuit court answered no. And number 3, whether the circuit court erroneously exercised its discretion in denying Mr. Avery an evidentiary hearing because its factual findings are unsupported by the evidence. The circuit court answered no. Statement on oral argument and publication. Pursuant to Wisconsin Statute 80922 from 2022, appellant does not request oral argument. A publication is warranted because the case is of interest to the public. Introduction. Mr. Avery appeals the circuit court's denial of his amended third post-conviction motion because the opinion erroneously relies upon false facts and misapplies the law in denying Mr. Avery's request for an evidentiary hearing. The circuit court misinterprets State v. Denny as requiring conclusive proof of motive to satisfy the materiality requirement of State v. Edmonds. It further erroneously requires the alleged third-party suspect to have the quote-unquote necessary skills to manipulate evidence in a manner that would implicate the defendant to satisfy the opportunity prong of Denny. This circuit court concludes Bobby's possession of Ms. Halbach's car does not directly connect him to her murder or the framing of Mr. Avery because, quote, Bobby could have been in possession of the car that night to help hide evidence to protect the two individuals directly linked by forensic evidence to this murder and convicted of the crime, end quote. The first footnote is just about the citations and how to read it.
No need to read that.
No.
Okay.
Furthermore, the circuit court relies upon Brendan Dassey's, quote, confession, end quote, stating that the confession, quote unquote, specifically implicated Mr. Avery in this crime to support its decision denying Mr. Avery relief. Brendan Dassey's confession was not admitted as evidence in Mr. Avery's trial, and the circuit court should know this basic fact. Second, the circuit court mistakenly believes Brendan was linked to the crime forensically. He was not. Another basic fact that has escaped detection by the circuit court. The circuit court proposes a completely irrational justification to explain Bobby's actions in moving Ms. Halbach's vehicle onto the Avery property. Bobby was trying to help his uncle by hiding evidence. In the circuit court's nonsensical conclusion, because these actions could be seen as an effort by Bobby to help Mr. Avery, Bobby cannot be considered a valid Denny suspect. The circuit court fails to explain why, if Bobby was simply lending a helping hand to his homicidal uncle, he would then become the state's primary eyewitness against Mr. Avery, or why all of the forensic evidence used to convict Mr. Avery is not discovered until Bobby moves Ms. Halbach's vehicle onto the Avery property. Statement of the case and procedural history. This case began in early November 2005 with the disappearance of Teresa Halbach, a 25-year-old professional photographer. On November 5, 2005, volunteer searchers found Ms. Halbach's Toyota RAV4 on the 40-acre site of Avery's Auto Salvage. After finding her RAV4, law enforcement searched the Avery property and over the next 4 months discovered evidence including burned bone fragments in and around a burn pit with DNA matching Ms. Halbach's, Mr. Avery's, and Ms. Halbach's blood in the RAV4, remnants of electronic devices and a camera, the same models as Ms. Halbach's, in a burn barrel, Ms. Halbach's RAV4 key in Mr. Avery's bedroom with Mr. Avery's DNA on it, Mr. Avery's DNA on the hood latch of the RAV4, deposited, the state later claimed, by his quote-unquote sweaty hands, and a bullet in Mr. Avery's garage containing Ms. Halbach's DNA. During the trial, Bobby was the state's primary eyewitness against Mr. Avery. According to Bobby, Ms. Halbach was last seen walking towards Mr. Avery's trailer on October 31, 2005. The state used Bobby's testimony to establish that Ms. Halbach never left the property alive. If Bobby had told the truth that he saw Ms. Halbach leave the property that day, Mr. Avery would never have been charged with her murder, pursuant to the state's theory, which did not involve Mr. Avery leaving his property. According to the state, Mr. Avery discharged his firearm into Ms. Halbach's head in his garage and burned her body for hours in his burn pit after putting her vehicle by the crusher. On March 18, 2007, Mr. Avery was convicted of first-degree intentional homicide, contrary to Wisconsin Statute 940-011A, and felon in possession of a firearm, contrary to Wisconsin Statute 94129-2A. The jury found Mr. Avery not guilty of mutilation of a corpse. On October 11, 2019, Mr. Avery appealed the circuit court's denial of his second post-conviction motion and its supplements. During the pendency of the appeal, a new witness, Mr. Thomas Sawinski, Mr. Sawinski, contacted Mr. Avery's current post-conviction counsel in December of 2020. On April 10, 2021, Mr. Sawinski provided an affidavit to Mr. Avery's current post-conviction counsel stating that he was a motor route driver for Gannett Newspapers, Inc., and delivered papers to the Avery salvage yard in the early morning hours of November 5, 2005. Prior to delivering the newspapers, he turned onto the Avery property and witnessed two individuals, Bobby Dassey and an unidentified older male with a long beard, suspiciously pushing a dark blue RAV4 down Avery Road toward the junkyard. The RAV4 did not have its lights on. Mr. Sawinski drove past and delivered newspapers to the Avery mailbox and then turned around and drove back toward the exit. When he reached the RAV4 still there, Bobby attempted to step in front of his car to block him from leaving. Mr. Sawinski came within 5 feet of Bobby and swerved into a shallow ditch to escape Bobby and exit. After Mr. Sawinski learned that Ms. Halbach's car was found later in the day, on November 5, 2005, he immediately contacted the Manitowoc Sheriff's Office. On April 12, 2021, Mr. Avery filed a motion for remand and stay of appeal to this court containing Mr. Sawinski's original affidavit. On July 28, 2021, this court issued a per curiam opinion upholding the circuit court's summary denial of Mr. Avery's claims raised in his 97406 motion and 2 supplemental motions. State v. Avery. However, this court instructed the following. As discussed below, we are not addressing Avery's most recent filing to this court. See our discussion of motion number 6, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new Wisconsin Statute 97406 motion. That motion would need to survive both Escalona, Naranjo scrutiny and be found to have merit, in which case the evidence presented might supply the missing quote-unquote direct connection. In that event, the VLCD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. Regarding certain claims, such as the alleged Brady violation pertaining to the witness, Mr. Kevin Romlow, reporting to law enforcement his observation of Ms. Halbach's RAV4 in the turnaround of State Highway 47 on November 3 and 4 of 2005, this court made no determination as to whether it would be barred. On August 16, 2022, Mr. Avery filed his third 97406 motion, amended motion. His motion set forth the newly discovered evidence of Bobby seen in possession of Ms. Halbach's vehicle after her disappearance. Affidavits from 2 witnesses, Mr. Kevin Romlow and Mr. Thomas Baresh, corroborate Mr. Sawinski's observations. Mr. Romlow observed Ms. Halbach's RAV4 parked at the turnaround on State Highway 147 and the East Twin River Bridge on November 3 and 4, 2005. He reported this to a Manitowoc Sheriff's deputy on November 4, 2005. Sometime before 2 a.m. on November 5th, Mr. Baresh observed Bobby driving the RAV4 in the area of Highway 147 and County Road Q in Manitowoc County. In his motion, Mr. Avery also raised Brady claims. He attached supporting documents showing Mr. Sawinski's phone call to the Manitowoc Sheriff's Office was suppressed by the state. Mr. Sawinski's ex-girlfriend whom he was dating on November 5, 2005, and Mr. Sawinski both identified Mr. Sawinski's voice on a recording of a phone call made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Pertaining to Mr. Avery's Brady claim concerning Mr. Romlow's observations, no law enforcement report was ever generated memorializing Mr. Romlow's conversation with the Manitowoc Sheriff Deputy. This court denied Mr. Avery's 97406 motion on August 22, 2023. Mr. Avery filed a timely notice of appeal on August 24, 2023. This appeal follows. Arguments. 1. Whether the circuit court improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of State v. Edmonds and Brady v. Maryland. This circuit court misapplied State v. Edmonds by requiring Mr. Avery to conclusively establish Bobby's motive to murder Ms. Halbach in his motion on its face in order to satisfy the materiality requirement of Edmonds. A. Standard of review. An appellate court reviews a circuit court's determination as to whether a defendant has established his or her right to a new trial based on newly discovered evidence or an erroneous exercise of discretion. This court will find an erroneous exercise of discretion if the circuit court's factual findings are unsupported by the evidence or if the court applied an erroneous view of the law. Edmonds. Here, the circuit court erred in both regards. B. Burden of proof. On a motion for post-conviction relief pursuant to Wisconsin Statute 97406, a defendant has the burden of proof. Wisconsin Statute 97406 to obtain an evidentiary hearing on a motion for a new trial on the basis of newly discovered evidence, the defendant first, quote, must show specific facts that are sufficient by clear and convincing proof, end quote, to demonstrate that, quote, 1, the evidence was discovered after conviction, 2, the defendant was not negligent in seeking the evidence, and 3, the evidence is material to an issue in the case, and 4, the evidence is not merely cumulative. That's from Edmonds. C, the argument. The circuit court found that Mr. Avery satisfied all the elements required to admit his newly discovered evidence, the Sawinski evidence, but for the materiality requirement of Edmonds. It erroneously imposed a new Denny requirement that Mr. Avery must establish that Bobby had a motive by conclusive evidence to commit the murder of Ms. Halbach to meet the Edmonds materiality requirement. Specifically, it stated, a review of the record and the defendant's argument reveal that he has failed to establish the third standard of the Edmonds test, as well as the motive element of the Denny test. With respect to the Edmonds test, the defendant argued that the evidence offered was material to an issue in the case because it established that there was a viable third-party suspect that could have committed the murder of Ms. Halbach, and such evidence was never presented to the jury for consideration, undermining confidence in the verdict reached. In order to meet that burden, the defendant had to prove that the evidence also met the standards set forth in Denny to be admissible as proof of a third-party suspect. The defendant failed to establish that Bobby had the requisite motive to commit the murder of Ms. Halbach. According to the circuit court, Mr. Avery would have to satisfy two tests for it to admit the affidavit of Sawinski into evidence. The circuit court improperly found the materiality of Mr. Avery's newly discovered evidence is exclusively contingent upon its satisfaction of the Denny test for admissibility. In determining that Mr. Avery's new evidence could only be material to the issue of a potential third-party suspect, it completely ignored its inherent materiality to other material issues in Mr. Avery's case. In Mr. Avery's third motion for post-conviction relief, he argued, the Sawinski evidence is material to several issues in Mr. Avery's case. It is material for establishing Mr. Avery's defense, that is, that a third party committed the crime against Ms. Halbach. Additionally, the Sawinski evidence is material to the evidence in the RAB4 being planted by Bobby, including Mr. Avery's blood and DNA. The RAB4 also contained the Halbach vehicle key and Ms. Halbach's electronic devices, which were discovered in Mr. Avery's bedroom and burn barrel, respectively. Further, the Sawinski evidence is material to impeach Bobby's trial testimony that Ms. Halbach never left the Avery property and that she was last seen walking toward Mr. Avery's trailer. The new evidence that Bobby had possession of Ms. Halbach's vehicle is highly material for evaluating the reliability of the forensic evidence used against Mr. Avery, which all happened to be derived from Ms. Halbach's vehicle. Crucially, it is also material to the credibility of the state's key eyewitness against Mr. Avery, Bobby himself. This court pointed out in its July 28, 2021 opinion, quote, the state's theory was that Avery shot Halbach in the head in his garage and threw her in the cargo area of the RAV4. He then burned the electronics and camera, cremated Halbach in a burn pit, transferred the remains to a burn barrel, and hid the RAV4 until he could crush it in the Avery car crusher, end quote. Mr. Avery's new evidence shows that the vehicle left the Avery property and was in the possession of a third party. Additionally, it debunks the state's theory against Mr. Avery that he kept the RAV4 on the Avery property by the crusher so he could crush it immediately. The evidence of Bobby's possession of Ms. Halbach's vehicle is material because it shows that Bobby had possession of the forensic evidence used to convict Mr. Avery. The vehicle was the crime scene by virtue of having all of the relevant forensic evidence in it, including Ms. Halbach's blood. The Sawinski evidence establishes that Bobby, the state's primary eyewitness, had control of the crime scene for a period of time. Despite police searches preceding the discovery of Ms. Halbach's vehicle, her electronic devices and key were not found until after it was found. The only logical conclusion to explain this is that all the items remained in her vehicle and were then moved by whoever had possession of her vehicle. If a third-party suspect had possession of Ms. Halbach's vehicle, numerous areas of reasonable doubt arise, such as that the forensic evidence in the vehicle is tainted by the third party having control of it before it was discovered by law enforcement on the Avery property. This would have created reasonable doubt in the jurors' minds, particularly since the state's primary eyewitness was the one in possession of the vehicle. Mr. Avery's new evidence also presents an alternative theory for the source of the forensic evidence used against Mr. Avery. See Edmonds. State v. Edmonds is the leading case on newly discovered evidence. In Edmonds, the defendant was convicted of the death of an infant she was caring for. The defendant filed a motion for a new trial over a decade after her trial and offered medical testimony showing a shift in mainstream medical opinion as to the cause of the types of injuries the infant suffered. The court found the evidence was material to an issue in the case because the main issue at trial was the cause of the infant's injuries, and the new medical testimony presented an alternate theory for the source of those injuries, Edmonds. Here, applying Edmonds, Mr. Avery's new evidence is material to a key issue in Mr. Avery's case, because Mr. Avery's new evidence that Bobby had possession of Ms. Halbach's vehicle after her disappearance presents an alternative theory for the source of the evidence used to convict Mr. Avery. The Sawinski evidence is additionally material because it completely calls into question the credibility of the state's key witness, Bobby's testimony, which allowed the state to argue that Mr. Avery had exclusive control of Ms. Halbach and her vehicle, containing all the forensic evidence, and that this evidence was not tainted by any third party. During its closing argument, the state emphasized the importance of Bobby's testimony, vouching for his credibility. Quote, "Again, an eyewitness without any bias. It is an individual that deserves to be given a lot of credit," end quote. With the new Sawinski evidence, as well as Mr. Romlow's affidavit, the state could not possibly have presented an unbiased Bobby to establish Ms. Halbach never left the property in her vehicle, and that she was last seen walking toward Mr. Avery's trailer. Its critical eyewitness link to obtaining Mr. Avery's conviction. Bobby was the only witness whose testimony the jury requested to, quote, "read or hear a transcript of," end quote. Clearly, by Bobby possessing the vehicle, there is a reasonable likelihood it would have affected the judgment of the jury in that Bobby would have emerged as a more likely suspect in Miss Halbach's murder than his recently released, wrongfully convicted uncle. Contrary to the state's representations to the jury, Bobby was biased and deserved no credit for his fabricated testimony. In regard to a motion for new trial, a reasonable doubt as to a defendant's guilt has been found to exist when the credibility of a witness critical to the state's case is completely called into question by newly discovered evidence. State v. Wilson. A new trial, quote, "A new trial is required if the false testimony could, in any reasonable likelihood, have affected the judgment of the jury," end quote. That's from Giglio v. United States. See also State v. Plude. Quote, "Wisconsin law has long held that impeaching evidence may be enough to warrant a new trial," end quote. In State v. Plude, the defendant presented newly discovered evidence that an expert witness lied about his credentials. The Supreme Court of Wisconsin found that because, quote, "the expert witness's testimony was a critical link in the state's case," end quote, quote, "his quasi-medical expert testimony creates a reasonable probability that the jury, hearing of his false testimony about his credentials, would have had a reasonable doubt as to Plude's guilt," end quote. Notably, in Justice Annette Ziegler's concurrence, she found the quote-unquote new allegations that the expert witness misrepresented his credentials created a serious question as to whether the interests of justice were served. Mr. Avery presents a stronger case about the materiality of his newly discovered evidence because it shows Bobby committed perjury in his trial testimony, and it taints all of the forensic evidence used against Mr. Avery, which resulted in his conviction. In this court's July 28, 2021 opinion, this court did not believe the impeachment of Bobby was material because it found significant forensic evidence linking Mr. Avery to the crime. However, the Sawinski affidavit establishes Bobby's possession of the Halbach vehicle, which taints the forensic evidence used against Mr. Avery. This strengthens the materiality of the impeachment evidence against Bobby. In his motion, Mr. Avery satisfied Edmonds. Once the 4 criteria of newly discovered evidence have been established, the court looks to whether a reasonable probability exists that a different result would be reached in a trial. The reasonable probability factor need not be established by clear and convincing evidence, as it contains its own burden of proof. Edmonds. With regard to a motion for a new trial, the correct legal standard when applying the, quote, reasonable probability of a different outcome, end quote, criteria is whether there is a reasonable probability that a jury, looking at both the old and the new evidence, would have a reasonable doubt as to the defendant's guilt. See also Plude. That says a court reviewing newly discovered evidence should consider whether a jury would find that the newly discovered evidence had a sufficient impact on other evidence presented at trial that a jury would have had reasonable doubt as to the defendant's guilt. End quote. The circuit court, again, failed to analyze Mr. Avery's evidence under the proper test because of its improper requirement that Mr. Avery satisfy the Denny motive prong in order to show materiality of his evidence. Even for purposes of Brady, it did not dispute that the prosecution suppressed the audio recording of Mr. Swinsky's call. Rather, it disputed the materiality and favorability of the evidence, find that Mr. Avery failed to establish a Brady violation with respect to the Swinsky evidence. Rather than making the required finding of no reasonable probability that a jury, hearing Mr. Avery's new evidence, could have a reasonable doubt as to Mr. Avery's guilt, the circuit court improperly engaged in weighing the evidence of the violent porn found on the Dassey computer and concluded that it does not conclusively show that it was solely acquired by Bobby on the computer. Number 2, whether the circuit court erred when it did not correctly apply State v. Denny to Mr. Avery's potential third-party suspect evidence. In his 97406 motion, Mr. Avery presented evidence implicating his constitutional right to present a defense that a potential third party committed the murder of Ms. Halbach. However, the circuit court did not correctly apply Denny to the admissibility of his evidence. It erroneously imposed a substantial certainty requirement upon it and misapplied Denny in its evaluation of whether it satisfied the Denny elements of motive, opportunity, and direct connection. A. Standard of review. This court generally reviews a trial court's decision to admit or exclude evidence under an erroneous exercise of discretion standard. State v. Wilson. However, when a defendant's constitutional right to present a defense is implicated by the exclusion of evidence, the decision not to admit the evidence presents a question of constitutional fact that this court reviews de novo. State v. Ramsey. B. Burden of proof. On a motion for post-conviction relief pursuant to Section 97406 statutes, the defendant must show his entitlement to relief by clear and convincing evidence. Roll v. State. C. Argument. Denny governs the admissibility of potential third-party perpetrator evidence in Wisconsin. Denny requires a showing that, quote, there must be a legitimate tendency that this third person could have committed the crime, end quote. State v. Denny. A legitimate tendency is demonstrated where the defendant can establish 1, a motive, 2, opportunity to commit the charged crime, and 3, provide some evidence to directly connect a third person to the crime charged, which is not remote in time, place, or circumstances, end quote. In its opinion, the circuit court acknowledged the standard for evaluating admissibility of evidence of a potential third-party suspect is set forth in Denny. However, rather than applying the Denny standard, it applied a stricter standard Wisconsin does not follow. In Denny, the Court of Appeals rejected the standard set forth by the California Supreme Court in People versus Green. Specifically, the Denny court disagreed with, quote, the Green Court's conclusion that such evidence must be substantial, end quote, stating, quote, we perceive this to be too strict a standard for the admissibility of such evidence and conflicts with our Supreme Court's pronouncements on the fundamental standards of relevancy, end quote. Denny at 623. The Denny court clarified, relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. This rule does not say that the evidence must tend to prove a fact in a substantial way. Rather than requiring any level of substantial certainty, Denny adopted the standard set forth in Alexander versus United States. There, the Supreme Court fashioned the legitimate tendency test, where the standard for evaluating the evidence is that it must show a legitimate tendency that the third party could have committed the crime. Alexander at 356 and 57. In adopting the Supreme Court's test for materiality, Denny elaborated, quote, we believe that to show a legitimate tendency, a defendant should not be required to establish the guilt of third persons with that degree of certainty requisite to sustain a conviction in order for this type of evidence to be admitted. Denny at 623. The Denny court differentiated between evidence which supports, quote, unquote, a legitimate tendency, and, quote, evidence that simply affords a possible ground of suspicion against another person, end quote, which is merely evidence, quote, tending to show that hundreds of other persons had some motive or animus against the deceased, end quote. Unlike the inadmissible type of evidence Denny describes, Mr. Avery's evidence is very specific to Bobby and establishes a direct connection between Bobby and the crime. Hundreds of other persons did not have possession of Ms. Halbach's vehicle and have photographs of young, mutilated females on the computer of which they were the primary user. Denny states, quote, as long as motive and opportunity have been shown, and as long as there is also some evidence to directly connect a third person to the crime charged, which is not remote in time, place, or circumstances, the evidence should be admissible, end quote. Where Mr. Avery has proffered evidence that Bobby had possession of Ms. Halbach's vehicle after she went missing, had most likely been conducting computer searches relevant to her murder, and was on the Avery property before and after her disappearance, no reasonable trier of fact, correctly applying the law, would find that Mr. Avery has not established some evidence directly connecting Bobby to the crime charged. 1. The circuit court erroneously evaluated the motive, opportunity, and direct connection elements of Denny. As this court pointed out in its opinion previously, evidence in support of Denny must be viewed in the aggregate. Rather than viewing Mr. Avery's evidence in the aggregate, the circuit court required Mr. Avery to present conclusive proof to satisfy each prong individually. However, quote, each piece of a defendant's proffered evidence need not individually satisfy all three prongs of the Denny test, end quote, from Wilson. Further, the Wisconsin Supreme Court has determined that the quote-unquote strength and proof of one prong may, quote, affect the evaluation of the other prongs, end quote. The circuit court completely ignored these well-established principles of law in evaluating the motive, opportunity, and direct connection elements of Denny. Number 2, motive element of Denny. In Mr. Avery's 97406 motion, he alleged the motive attributed to Bobby for Ms. Halbach's murder could have been sexual and provided evidence supporting this, namely suppressed evidence from a computer that was in Bobby's bedroom. According to his brother Blaine, Bobby was the primary user of this computer. Bobby lied to police about its location, claiming it was in the living room, but crime scene footage showed it was in his bedroom. The computer was examined and revealed searches relevant to Ms. Halbach's murder, occurring during times in which the state has been unable to rule Bobby out as having conducted them. The state argued that other members of the Dassey household could have conducted them, a supposition that may or may not be true. But no other member of the Dassey household was spotted by an eyewitness with Ms. Halbach's vehicle shortly after her disappearance. Bobby's possession of the vehicle, with all of the forensic evidence used to convict his uncle, combined with the violent pornographic searches on the computer in his bedroom, of which he is the primary user, elevate him to the level of a Denny third-party suspect. The circuit court spent 12 pages of its 31-page opinion improperly weighing Mr. Avery's motive evidence, contrary to the law on motive. The issue is whether the pornographic searches on the Dassey computer are relevant to motive regardless of the weight. In its opinion, the circuit court noted, quote, the state further disputes the defendant's conclusions that law enforcement considered pornography or sexual assault as a motive for the murder in this matter, end quote. However, this point is completely refuted by the record. On March 10, 2006, the state filed an amended information against Mr. Avery, adding the charge of sexual assault, among others. Mr. Avery's trailer and his computer were searched extensively for pornography, and none was found. Detective Veely was asked to generate a report of Mr. Avery's computer. Based on his report, no apparent searches of pornographic and/or sexual images were made, and no websites with apparent sexual and/or graphic images were accessed. In further search of evidence to support a sexual assault motive, the Dassey computer was seized by law enforcement on April 21, 2006. In the affidavit for search warrant for Dassey computer, Special Agent Tom Fassbender attested, your affiant believes that said computer may contain images, records, and messages which may be relevant to the investigation into the homicide of Teresa Halbach. Your affiant further believes that information contained on said computer may include evidence of the crimes of homicide, mutilating a corpse, and sexual assault. The circuit court incorrectly relied upon the state's misrepresentations that the investigation was not focused on a sexual motive. Law enforcement made great efforts to extract all the pornography from the Dassey computer, and even went so far as having Detective Veely conduct specific word searches related to the murder in an effort to connect the searches to the murder. Detective Veely searched words that he believed were directly related to Ms. Halbach's murder, generating 2,632 search results, including body, 2,083, stab, 32, throat, 2, bullet, 10, DNA, 3, fire, 51, gas, 50, RAV, 74, gun, 75, handcuff, 2, bondage, 3, Blood 1, Tire 2, Journal 106. In the context of Ms. Halbach's murder, all these terms are relevant. 2 bullets from a gun pierced her skull. There was a fire ignited by gas and tires, which burned her body. She bled in her vehicle, so she may have been stabbed. Her DNA was found on a bullet, and she did keep a journal. Mr. Avery's blood was in the RAV4. Veely's CD contains the state's recovered pornography images relevant to her murder. On the CD, Detective Veely refined 14,099 images on 7 DVDs and recovered 1,625 violent pornography images that had been deleted. Mr. Avery has been unable to get an affidavit from Bobby admitting he conducted the searches, or someone from the Dassey household stating they saw Bobby performing them, which the circuit court seems to require. Bobby did not volunteer for a forensic or psychological examination by Mr. Avery's experts, as the circuit court also suggests is required. However, Brendan Dassey was arrested on March 1, 2006, and can be eliminated from a majority of the searches. Brian Dassey was interviewed and stated that he did live in the Dassey trailer and did not know anything about the computer. Blaine Dassey, who was living there, denied ever doing a single pornography search on the computer. Bobby was the only Dassey household member who admitted that he may have watched porn on the computer. Importantly, Bobby cannot be eliminated by the state from any of the pornographic searches, especially the ones conducted prior to and very close in time to Miss Halbach's murder. And he is the only family member who had unexplained scratches on his back on November 9, 2005, which have been identified by Mr. Avery's forensic pathologist expert as caused by human fingernails, and the only family member seen by witnesses with Ms. Halbach's vehicle after her disappearance. The circuit court erroneously concluded the searches done after Ms. Halbach's murder have no weight. Conduct of a suspected person after the crime is a legitimate subject for consideration as bearing upon the probability of his guilt. Motive can manifest itself after the crime, when the perpetrator is reliving and fantasizing about the crime. It is highly significant that the searches for deceased, mutilated young women began after, not before, the murder and mutilation of Ms. Halbach. The searches after the murder coincide with the fact that a young woman was murdered and mutilated. The searches before the murder coincide with thousands of images of young women engaging in sexual activity, many unwillingly, and corroborate a sexual assault motive. See State v. Silva. The circuit court also completely ignored Mr. Avery's evidence of Dassey computer deletions, which infers a consciousness of guilt. There were 8 periods of deletions on the computer, correlating with Ms. Halbach's visits to the property. The deletions cannot simply be dismissed as mere coincidences. It is highly significant in any investigation if there is an attempt to delete or destroy records. See, for example, State v. Rainier, where the appellate court found, quote, the defendant's consciousness of guilt was also evidenced as he told the victim to delete the text messages the two had exchanged, end quote. State v. Mercer, where the appellate court found, quote, evidence from which the jury could infer that Mercer deleted the files where the forensic examiners would have found the child pornography stored in his hard drive, end quote, was significant evidence of the defendant's guilt. This circuit court misconstrued the holding in Dressler v. McCautry by adopting the state's argument that pornographic images must be a mirror image of the crime or they have no relevance. The court in Dressler made no such ruling and held, quote, "The pictures depicting violence were offered to prove Dressler's fascination with death and mutilation, and this trait of Dressler is undeniably probative of the motive, intent, or plan to commit a vicious murder," end quote. Likewise here, most of the Dassey computer pornography consists of images depicting violence, even race car accidents, showing a fascination with death and mutilation. And this trait of the Dassey pornographic consumer is, quote, "undeniably probative of a motive, intent, or plan to commit a vicious murder," end quote. Mr. Avery provided the circuit court with specific searches on the Dassey computer of terms such as, quote unquote, "someone who was shot," and, quote unquote, "gun to head." There are 8 searches prior to Ms. Halbach's murder on 9/17/05 for skeleton and a live skeleton. After Ms. Halbach was reported missing, there were 6 searches for girl guts, 15 searches for girl hurt, and 2 searches for seeing bones, hot girls. These mirror the fate of someone hurt, shot in the head, mutilated, and burned into skeletal remains, which is the total amount of information known about Ms. Halbach's fate. Contrary to the circuit court's view, the proper standard does not require Mr. Avery establish his motive evidence, which with absolute certainty. This level of certainty has never been required by any Wisconsin court to satisfy the motive element of Denny, or any element of the Denny analysis for that matter. See State v. Knapp, where the Wisconsin Supreme Court has even deemed hearsay permissible evidence for satisfying all 3 prongs of the Denny test, including motive. Under the motive prong, the court simply must question whether, quote, "the alleged third-party perpetrator had a plausible reason to commit the crime," end quote. That's from Wilson. Also, see State v. Volbrecht, where evidence of a general motive is sufficient to prove this prong of the Denny test. Further, because motive is never an element of any crime, the state never needs to prove motive. Relevant evidence of motive is generally admissible, regardless of weight. Wilson. See also State v. Burby. Mr. Avery's third-party motive evidence is relevant, regardless of the weight assigned to it by the circuit court. This is precisely the reason this court found that if Mr. Avery's new direct connection evidence survives Escalona Naranjo scrutiny and has merit, the motive evidence found in the Veely CD, quote, "might become relevant to showing Bobby's motive and might bear on whether Bobby is or should have been a viable Denny suspect," end quote. Note 26, emphasis added. Mr. Avery offered his motive evidence in conjunction with evidence of Bobby's opportunity and direct connection to Ms. Halbach's murder and framing of Mr. Avery. Evidence of motive that would be admissible against a third party, or that third party, the defendant, is admissible when offered by a defendant in conjunction with evidence of that third party's opportunity and direct connection. Wilson. In rehashing the weight of Mr. Avery's prior motive evidence contained on the Veely CD, which this court already assessed was not sufficient in and of itself, but could be relevant if Mr. Avery could also show Bobby's direct connection. Footnote 2, this court stated, quote, "the evidence presented might supply the missing direct connection." The circuit court evaluated the CD evidence in isolation, contrary to this court's prior directive. See also Wilson. The strengthened proof of one of the prongs may affect the evaluation of the prongs. Mr. Avery's powerful direct connection evidence certainly affects the evaluation of the other prongs because it provides evidence supporting all three prongs. For example, even if the motive for Ms. Halbach's murder was not sexual, as law enforcement believed, the Sawinski evidence offers evidence that the motive could have even been robbery. Footnote 3. Accepting the Sawinski evidence as true, there is now proof that Ms. Halbach's vehicle and the items within the vehicle were stolen. Many things were missing from Ms. Halbach's rapport that should have been present, such as Ms. Halbach's purse, wallet, and money she received that day. The motive for her murder may have been a theft by Bobby of her vehicle and the items within it. Wisconsin cases discussing the motive element of their Denny analysis show that the standard for fulfilling it is not overly burdensome, especially when there is strong evidence of a third party's direct connection to the crime. For example, State v. Ramsey is a case in which the defendant presented weak evidence of a motive against a third party. However, the appellate court found strong evidence of a direct connection and thus, quote, plausible reasons, end quote, for the third party to commit the crime. In Ramsey, the victim was found stabbed at a home. The 911 caller told police that the victim had been staying at her sister's home to hide from the defendant. The defendant was in a relationship with the victim for over 11 years and had a history of domestic violence. He admitted stabbing the victim twice to police officers. The victim's best friend told police that the day before the stabbing, the victim told the defendant that she was going to leave him. After fingernail clippings from the victim revealed another man's DNA, the defendant brought forth a Denny motion, arguing that a potential third-party perpetrator, 1, was a convicted criminal, 2, lived near the crime scene, and 3, his DNA at the scene is unexplained. The defendant alleged, quote-unquote, possible motives for the third party, irrational rage and antisocial behavior, and/or sexual gratification, and argued it was possible they had no rational motive. Thus, he presented evidence of a general motive not directed at the victim. The circuit court found the defendant failed to establish third-party motive, denying the motion. However, the appellate court reversed the circuit court, concluding, when considered under the applicable law regarding motive, and with the opportunity evidence and the strong direct connection evidence, Ramsey has presented plausible reasons for the third party to commit the crime, end quote. It found, quote, under the totality of the circumstances, the evidence suggests a third-party perpetrator actually committed the crime. Emphasizing suggests is a rather broad term, end quote. Here, the circuit court's failure to consider the Denny prongs in the aggregate and its erroneous imposition of a substantial certainty burden on Mr. Avery's motive evidence results in a fatally flawed opinion on the law and the facts. Number 3, opportunity element of Denny. In regard to the Denny opportunity element, the circuit court found, quote, even if the defendant had met the burden with respect to its motive element of the Denny test, he has not met the burden with respect to the element of opportunity, end quote. Undisputably, Bobby was on the Avery family property when Ms. Halbach was, and before and after she was reported missing. Normally, even proximity to the murder is sufficient to show, quote-unquote, opportunity. However, the circuit court improperly imposed a burden on Mr. Avery to prove Bobby had the skills, contacts, tools, time, and/or other means necessary to have committed this crime and staged the scene in order to satisfy the opportunity element of Denny. It cited State v. Wilson for its requirement that Mr. Avery prove this. However, this principle came from a Kansas Court of Appeals case the state cited in its brief, State v. Kreider. The Kansas case, Kreider, is completely inapposite. In Kreider, the defendant's proffered potential third-party perpetrator evidence consisted of alleging a potential motive for the victim's son-in-law to kill her, and that his wife would benefit from the inheritance, and that he could have had the opportunity to get defendant's hair from headgear and blood from used bandages to later plant at the crime scene because he worked as a first aid officer at the defendant's work. The court found the evidence did not effectively connect the third party to the crime, finding, quote, "It is nothing more than mere speculation and conjecture and does not connect the third party to the crime, and therefore the district court did not err in excluding it." End quote. Kreider. Likewise, the facts of Wilson are completely distinguishable to Mr. Avery's case. In Wilson, multiple eyewitnesses identified the defendant as the shooter. The defense's theory was that an unidentified hitman was hired by the man in the car with the victim, and the hitman shot the victim. The Wilson court found there was no evidence showing the man in the car had the opportunity to hire a hitman in the brief time he was in the car with the victim before she was shot. The defense failed to present any evidence of contacts, influences, or finances used to hire a hitman to corroborate its hypothetical theory that the potential perpetrator was some unidentified hitman. Thus, the court found, quote, "Wilson's proffer failed to demonstrate that these alleged assassins were anything but purely hypothetical people." End quote. Wilson, 2015. Importantly, Wilson is not a case about planting evidence or framing, but specifically stated that this type of theory only requires a showing of access to frame. Quote, "If the defense theory is that a third party framed the defendant, then the defense might show opportunity by demonstrating the third party's access to the items supposedly used in the frame-up." End quote. The circuit court erroneously reasoned that, pursuant to Wilson, Mr. Avery must prove Bobby had the, quote, "scientific knowledge to recognize the significance of each piece of forensic evidence supposedly planted by him, let alone establish that he had the skill to plant that evidence in a way that would stand up to scientific scrutiny by professional crime scene analysts." End quote. Unbelievable. This is not the standard for showing a third party framed the defendant. Evidence that the third party had access to the items used in the frame-up is sufficient, pursuant to Wilson. The circuit court imposed upon Mr. Avery a standard for satisfying the opportunity element of Denny that has never before been applied in any Wisconsin case. State v. Volbrecht is a case in which the evidence of connection and motive carried the strength of the opportunity evidence. The trial court granted a new trial, and the appellate court affirmed. Although the evidence only theoretically put the third party in the geographic area of the murder, the appellate court focused on the strength of the motive and the direct connection evidence. The facts of Volbrecht are similar to those in Mr. Avery's case, as both defendants were convicted based largely on circumstantial evidence. In Volbrecht, the defendant was convicted of first-degree murder and sexual assault after a woman, shot in the back, was found in a wooded area, naked and hanging from a tree by tire chains. The defendant had been with her the day before she was reported missing. He told police that he was dropped off by her, but detectives spoke to several people who knew him, and were in the area he claimed he was dropped off, and no one saw him. Police interviewed a witness who identified him as being near the area where the victim's body was found the day she was reported missing. The defendant's hairdresser told police that he told her, "I didn't do it, and if I did, I don't remember doing it." A witness who lived near where the victim was found testified that he woke up and heard shots around 2:50 a.m. and the sounds of a car dragging, which stopped and started up again 20 minutes later, which showed the victim was murdered before the time the defendant estimated he had parted ways with the victim. Volbrecht filed a 97406 motion based on newly discovered evidence of a third party convicted of a similar killing 6 weeks later, stemming from the discovery of reports that a search of the third party's residence uncovered a revolver and books involving rape, chains, and torture, statements to co-workers about tying girls up, abusing them, and getting rid of them, and statements to inmates that he liked to chain and burn women. The state took issue with the opportunity prong of Denny being fulfilled, noting the third party lived 30 miles from where the victim was found and killed the other victim 30 miles away. It argued that opportunity evidence must be more than just a theoretical possibility of committing the crime. However, the appellate court rejected this and found, quote, "The record reflects that the post-conviction court's determination as to opportunity was made in light of the evidence presented as to motive and direct connection. We agree. The facts give meaning to other facts, and that the significance of the third party's opportunity to commit the crime depends on his alleged motive and direct connection," end quote. In Mr. Avery's case, the opportunity element has already been decided. According to the trial court, trial defense counsel established Bobby had the opportunity to commit Ms. Halbach's murder because of his presence on the property at the time Ms. Halbach was there. The Sawinski evidence greatly strengthens Mr. Avery's evidence of Bobby's opportunity to commit Ms. Halbach's murder because it shows Bobby was in possession of her vehicle, where her murder likely occurred. He had access to Ms. Halbach's vehicle and all the evidence used to convict Mr. Avery of her murder. Correctly applying Wilson, Mr. Avery has not only shown Bobby's opportunity because of his proximity to the murder, but also because he had access to the items used in the frame-up. The defense theory of a third party's involvement will guide the relevance analysis of opportunity evidence in a Denny case. From Wilson. Excuse me. Rather than accepting this, the circuit court found that Bobby needed some kind of expert scientific knowledge to plant evidence. There is no scientific knowledge necessary to know that planting someone's blood in the vehicle of a woman that went missing is incriminating. Common sense suffices to make this deduction. The circuit court did not explain what special skills it took to shoot Ms. Halbach in the head that Bobby lacked. All that was required was to pull the trigger. Bobby was a skilled deer hunter with a .22 rifle who had obviously pulled many triggers. For planting blood, the only skill required is using a wet sponge to remove Mr. Avery's blood from his sink and dumping 1 to 2 milliliters into the RAV4 and applying it to the dashboard with a household item such as a Q-tip. Mr. Avery told law enforcement in a recorded interview that his finger, which had been cut open prior to October 31, 2005, re-bled on November 3, 2005, and dripped blood in his bathroom sink and on the bathroom floor. Mr. Avery told law enforcement and his trial defense counsel that as he was leaving his property on November 3, 2005, and exiting onto Highway 147 He observed taillights of a vehicle close to his trailer. He told trial defense counsel he noticed the blood had been removed from his sink when he entered the bathroom early in the morning on November 4, 2005. The bullet fragment found on Mr. Avery's property simply had to be rubbed in Ms. Halbach's blood or on her skin cells, both of which her murderer had access to before her body was burned. This court determined, quote, the state did not argue that this specific bullet entered Halbach's skull or killed her, end quote. And there were no bone fragments on the bullet. It is undisputed that there were bullets all over Mr. Avery's property from Raleigh Johnson shooting gopher holes with his .22 rifle, as well as Jody Stokowski firing it. This was the gun that fired the bullet found on Mr. Avery's garage floor with Ms. Halbach's DNA on it. No skill was required to plant the electronic devices in Mr. Avery's burn barrel. The fact that there were burn barrels at the Dassey property, 4, one of which contained human bones, shows the Dasseys, including Bobby, were proficient in burning material in their burn barrels. Part of the circuit court's certainty of Mr. Avery's guilt is based on another factual error. Its belief that all of Ms. Halbach's remains were found in the Avery burn barrel. They were found in a Dassey burn barrel. Dr. Eisenberg claimed that when she opened the container of bones from the Dassey burn barrel, she got a, quote, waft of flammable liquid or fluid, end quote, but did not smell burned rubber from tires, which the state claimed was the accelerant Mr. Avery used. This suggests Ms. Halbach's body was burned in a Dassey burn barrel and dumped in Mr. Avery's fire pit. Common sense suggests that Mr. Avery would not have been planting evidence to incriminate himself. The circuit court erroneously stated that Mr. Avery argued that Bobby planted the key to the RAV4 in Mr. Avery's trailer between November 3 and November 5. There was no such argument. Bobby would have had the key when he planted the vehicle on November 5 because it was locked when it was discovered. So whoever left it on the Avery property necessarily had the key and locked it. Bobby had access to Mr. Avery's unlocked trailer from early Saturday morning, November 5, until shortly before noon, when the vehicle was located and the Avery property was secured by law enforcement. Mr. Avery and his mother left for their Crivets cottage early Saturday morning. Per the circuit court's criteria, Mr. Avery was even less qualified to commit the murder than Bobby. He was less educated than Bobby, never having graduated from high school. He was less skilled because he never held a job because of his wrongful conviction, whereas Bobby was employed as a third shift worker at a furniture factory. During all the years Mr. Avery was incarcerated for his first wrongful conviction, Bobby had been honing his skills in stalking, hunting, killing, burning, and dismembering game. Further, the court erroneously presupposed the forensic evidence against Mr. Avery stood up to scientific scrutiny in Mr. Avery's trial. Mr. Avery's defense team never presented the required experts to attack it. Mr. Avery, in his second post-conviction motion, presented voluminous evidence from numerous experts that the forensic evidence used to convict Mr. Avery was vulnerable to being discredited had the defense presented experts such as DNA, trace, blood spatter, fire, forensic pathologists, and ballistics experts. This court determined, quote, certainly, these conclusions tend to support Avery's general theory that he was framed, and their presentation may have been useful at trial, end quote, but concluded that Mr. Avery's experts' evidence failed to show, quote, how its introduction at trial could reasonably have led to a different outcome, end quote. Mr. Avery previously presented an affidavit stating that he noticed his toothbrush was missing in the law enforcement photos taken from the bathroom in his trailer. In regard to the hood latch swab, Mr. Avery is not abandoning his theory that the illegally collected groin swabs taken from him on November 9, after his arrest on a gun charge, were substituted for the hood latch swabs when they were delivered to the Wisconsin Crime Laboratory by Investigator Wiegert, who signed Deputy Hawkins' name instead of his own. However, for purposes of demonstrating Bobby had the skill to plant DNA on both the hood latch and Ms. Halbach's key, Mr. Avery asserts that Mr. Avery's toothbrush could have been rubbed on both. Bobby had access to Mr. Avery's trailer, where his toothbrush resided before disappearing. Any teenager watching an episode of Forensic Files could learn how to plant DNA. Certainly, the DNA searches on the Dassey computer bolster the assertion that DNA information was readily available. Number 4. Direct connection element of Denny. No bright lines can be drawn as to what constitutes a third party's direct connection to a crime. Rather, circuit courts must assess the proffered evidence in conjunction with all other evidence to determine whether, under the totality of the circumstances, the evidence suggests that a third-party perpetrator actually committed the crime. Wilson. In its opinion, the circuit court argued, quote, "The Sawinski affidavit, taken as true for the purpose of this motion, directly links Bobby to possession of the victim's vehicle. However, possession of the vehicle does not directly link Bobby to the homicide itself," end quote. Then it highlighted, quote, "Mr. Sawinski's affidavit does not mention seeing Bobby with the key to the victim's car," end quote, ignoring the fact that when her vehicle was found by law enforcement in voluntary searches, it was locked. Clearly, Bobby had to have the key to the vehicle. In State v. Williams, footnote 4, Mr. Avery realizes this case existed 2 months before it was found to not have precedential value. However, it is noteworthy for employing a common sense approach that possession of a murder victim's stolen car means the thieves probably committed the murder. Okay. In State v. Williams, the appellate court found a direct connection between the perpetrator of the murder and the fact that he had possession of a victim's vehicle several days later, explaining, "From all of these circumstances, under a common sense, non-technical approach, a reasonable police officer would draw the reasonable inference that both Williams and Armstead had been in possession of Brown's stolen car. There was probable cause to believe that both Williams and Armstead probably had committed a crime involving the murder victim's stolen car." Applying this common sense, non-technical approach, the Sawinski evidence provides the direct connection, that is, Bobby being witnessed in possession of Miss Halbach's vehicle, to Bobby having committed the murder of Miss Halbach and planting the evidence to frame Mr. Avery. Rather than recognizing the significance of the evidence of Bobby having possession of, and thus access to, Miss Halbach's vehicle, the circuit court required Mr. Sawinski to witness Bobby in possession of the electronics. However, a reasonable inference can easily be made that because they had not yet been found by law enforcement when Bobby was seen with Miss Halbach's vehicle, they were still inside the vehicle and he planted them in Mr. Avery's burn barrel. In State v. Knapp, vacated on other grounds, the Wisconsin Supreme Court found hearsay evidence implicating a potential third party in a murder was properly admitted because it established the requisite quote-unquote direct connection pursuant to Denny. In Knapp, the defendant was the last person seen with the victim. During trial, the defendant sought to introduce evidence of potential suspects, including the victim's husband, Bruner, and the woman he was having an affair with, Mass. Specifically, the defense sought to introduce the testimony of a witness, Farrell, who was close friends with the man, Borchardt, whom Mass had lived with at the time but had since passed. Through Farrell, the defense sought to introduce statements Borchardt made about Mass's behavior and Bruner's truck at the Mass's residence after the murder. The Wisconsin Supreme Court found that the third party of the Denny analysis, the connection, was at issue and found the evidence at issue connects the third parties, Bruner and Mass, to the crime in a number of ways. 1, it establishes that Bruner lied to investigators about his whereabouts at the time of the murder. 2, Mass was with Bruner at the time his wife was murdered, and Mass was observed a short time after Mrs. Bruner's death carrying a paper bag and getting into Bruner's waiting truck. And 3, most importantly, the evidence puts Bruner in Watertown in relative proximity to the location where the homicide occurred and near the time of the murder. Based upon these 3 inferences from the hearsay evidence, the court held, quote, the circuit court correctly determined that the evidence established Bruner's motive, opportunity, and connection to the crime, end quote. If the same reasoning were applied to Mr. Avery's case, the circuit court would have found far stronger evidence of a direct connection to allow the defense to present Bobby as a potential third-party suspect pursuant to Denny. At bare minimum, the Sawinski evidence connects Bobby to Miss Halbach's murder in all the same ways the hearsay evidence did to the third party in Knapp. 1, it establishes Bobby lied to investigators about his whereabouts during times relevant to Miss Halbach's murder, noting, of course, the exact time of Miss Halbach's murder is unknown. Number 2, like Mass, who was observed carrying a paper bag after the murder, which the Wisconsin Supreme Court found material, Bobby was seen with the victim's vehicle after Miss Halbach's murder. And 3, the evidence certainly put Bobby in close proximity to where the homicide is alleged to have occurred, and that, combined with evidence showing that Bobby, according to his own testimony, was one of the last people to see Miss Halbach alive, would have satisfied Denny had the circuit court applied only the reasoning in Knapp. Number 3, whether the circuit court erroneously exercised its discretion in denying Mr. Avery an evidentiary hearing because its factual findings are unsupported by the evidence. This court will find an erroneous exercise of discretion if the circuit court's factual findings are unsupported by the evidence. Edmonds. The circuit court's egregious factual errors should result in a reversal of its decision. In order to dismiss Mr. Avery's third-party motive evidence, the circuit court argued, quote, only a small number of searches were conducted prior to the murder of Ms. Halbach. No physical evidence directly linking Brian Dassey to the homicide was found in the house, end quote. The circuit court is incorrect about there being a quote-unquote small number of searches prior to the murder. For example, September 18, 2005, there were 75 searches of violent, child, or underage pornography performed on the Dassey computer, obviously prior to Ms. Halbach's murder. Further, the circuit court's reference to Brian Dassey is perplexing and confusing. Brian was never linked to the murder in any way. In order to dismiss Mr. Avery's direct link between Bobby and Ms. Halbach's murder, the circuit court erroneously found that Ms. Halbach was murdered on October 31st, but there is no proof of when Ms. Halbach was murdered up until her remains were found on November 7th. The circuit court erroneously believed that Ms. Halbach's bones were found in Mr. Avery's burn barrel. No bones were found in Mr. Avery's burn barrel, but some of Ms. Halbach's larger bones were found in the Dassey burn barrel. In order to dismiss Mr. Avery's claim that Bobby had the opportunity to frame him, the circuit court relied upon a belief that every bone from Ms. Halbach's body was found in Mr. Avery's burn pit, and therefore Bobby could not have planted the bones in Avery's burn pit. Once again, this is a false fact because it is undisputed that 40 to 60% of the bones comprising the complete skeleton of Miss Halbach were never recovered. The jury was unconvinced that Miss Halbach was burned by Mr. Avery in his burn pit because he was acquitted of the mutilation of Miss Halbach's body. Further, the circuit court relied upon Brendan Dassey's confession and its belief that Brendan was forensically linked to Miss Halbach's murder to reject Mr. Avery's theory that Bobby framed him. Brendan's confession was not introduced into Mr. Avery's trial, and it is wholly improper for the circuit court to have factored the alleged confession into its analysis. Furthermore, Brendan was not forensically linked to the crime. Even if the circuit court's numerous factual errors were correct, and Brendan Dassey was, quote, directly linked by forensic evidence to this murder, end quote, and his, quote unquote, confession was admissible evidence against Mr. Avery, this still does not allow the circuit court to dismiss the powerful evidence of a third party's direct connection to the murder. Overwhelming evidence against the defendant may not serve as the basis for excluding evidence of a third party's opportunity or direct connection to the crime. Wilson, quote, by evaluating the strength of only one party's evidence, no logical conclusion can be reached regarding the strength of the contrary evidence offered by the other side to rebut or cast doubt, end quote, from Holmes versus South Carolina. The circuit court has ignored the strength of Mr. Avery's evidence and reached an illogical conclusion which favors the state by misapplying the law and misinterpreting the facts. Conclusion. For the reasons stated herein, Mr. Avery respectfully requests that this court grant him one of the following alternative remedies. 1. Reverse the orders denying post-conviction relief and grant an evidentiary hearing. 2. Reverse the judgments of conviction and the orders denying post-conviction relief and remand for a new trial. And 3, grant any other relief this court deems appropriate. Dated today. Kathleen Zellner.
Well, round of applause for Susan. Read it all the way through. Badass.
Badass for sure.
She never took a break, man.
It was fun.
Hey, Jay. Thanks for coming.
No problem. I'm stuck on the side of the road in the service station. I'm going home. I pulled over.
Oh, wow. And poor Neverly stuck at work. She tried to hide in a closet, but that didn't work.
Oh, well.
Oh, that's fun.
Well, what did I know what I thought about this. What did y'all think?
Well, she's condensed it down a little bit, so she's within her page limit. So.
I think it was full of common sense myself. Sorry, Kate.
I thought I looked it up when all those motions are when the whole after she filed it the first time over the limit. I thought it was 50 pages that she was allowed. So it's interesting to see she cut that by 5.
Yep.
I think it may be pages and word count. I'm not sure.
I was going to ask you that earlier, Susan, if it was either or.
I think it's
I think
both.
it may be K, but yeah, I'm not positive.
Oklahoma
think
is
that's-
just pages, not word count.
Well, they have to use a certain font, I think.
Yeah, format.
It has to. Yeah, it has to be a certain size, laid out a certain way,
Mm-hmm.
so they don't
Yeah.
get a bunch of different, briefs and so forth from the various appeals that get passed their way. And I understand that.
They were very strict about it in law school. Like, if you went over, like, ran out of time and didn't have time to make, this happened to me once, so I know it very well. I had it written, but it was too long, but I ran out of time to make it shorter. Well, the teacher just stops reading at the like 1,800 words or whatever. And so you don't get credit for the rest of it. And that can really hurt you. So they try to teach you.
I see an interesting comment that Duke made about Casey stating that her TH's remains were first found on November 7th. I noticed that as well, when we know that it was the 8th. Well, we don't know. Cuss Road was the 7th.
And she said the 7th,
yeah.
but officially it was the 8th.
Yeah, according to the state.
According to the state, yeah. Well, I think that her introduction was really, really harsh and spot on. And she's definitely went after Judge Angie for all the mistakes. I mean, she really went after her.
Rightly so. And rightly so.
Oh, I agree.
Angie's rulings were just inexplicable.
Yeah, inexplicable. Yeah, you know that one very well. Mm-hmm.
I do.
It's just so frustrating to see some of the shit the judges have the nerve to put in a decision.
Yeah.
I mean, it shows you, and it's sickening when you're in a county where there are more corrupt people than honest people. I mean, Oklahoma feels just like a cesspool right now between what I know about Oklahoma County and now what I know about Tulsa County. It's disgusting.
Are you talking about that case that video we were discussing before we went live?
Yeah, that and a few other things that I came across.
It's absolutely frightening. Yeah.
Well, I mean, they just destroy people's lives, and not just those people, but I mean, that kind of shit just ruins families financially and emotionally, physically.
And they don't seem to care one iota.
I mean, and people who are climbing the ladder, and that's what they're doing, is all they care about is, how does this help me? How does this benefit me? Is this good for me? You can shit on all these people and just destroy their lives just so you can get a promotion or be a more high profile attorney or whatever the case may be.
Some people just have no conscience.
Run for political office. It seems like there's more of that than honest people in our legal system right now. It's just disgusting.
It sure does. Seems that way to me too.
Duke made another interesting comment. I wouldn't doubt that Judge Ange walked away from the case because she knew she was going to get hammered after what she wrote. Yeah, it is interesting after, a decade or more actually being tied to Avery's cases.
I have to agree with that. Yeah.
Yeah, it's hard to say, and we probably will never know if, the chief judge took a reading like, what the hell are you doing here? What is this? We don't know. I mean, that's pure speculation.
Maybe the chief judge, whoever that is the chief judge honest? I mean, if not, maybe the chief judge was happy to pass that one on to her to do her part. Because it definitely, I mean, she can't be that stupid.
Oh, no, she's been a judge too long. She knows the law.
I mean, that's ridiculous. And that's just the power that they have to I'll just say a bunch of shit and then sign my name and that'll be that. And
well,
then,
yeah, zero or little repercussions is.
Yeah,
right?
Qualified immunity is, I mean, well, with judges, but with prosecutors, but none of these prosecutors or judges rarely face any repercussions for these things.
Yeah.
More defense attorneys get disbarred for pointing out the corruption than anything.
Right.
Sure. Dr. Silkman made a good point here. The state didn't have a DNA standards for Teresa until they got the pap smear, and which we know they didn't pick that up until the 21st of November.
Right.
So that brings in, other questionable things that were said at trial.
After her death certificate was signed, yeah.
That's right.
Duke had mentioned that there was a number posted after that, November 7th. And it's 1132:25. I'm not sure what that's referring to.
Got to be trial testimony, maybe.
Perhaps. I mean, there's a bunch of those.
Yeah.
It probably is.
Yeah.
Where she got her November 7th from.
I might be able to look where you guys are talking. I might have the full trial testimony here on my hard drive somewhere. Favorite trial.
Do you reckon 11th of November is going to bring in Cuss Road, and that's KZ's way of bringing that in?
Well, I don't know.
Duke says he'll look into it also.
And I'm looking at the full jury trial, page 1125.
It was 1132. What did I say? 1132:25.
Oh.
I don't know.
What page again? $11.30.
1132.
Yeah, 1132:25. Almost like a time with the colon. I don't know.
No, this is talking about.
Maybe that's a page number and a line number.
That's what I'm looking at. The full jury trial. At page 1132. It's Kratz and it's Kratz and Buting having apparently a sidebar, and I think it's
when her remains were found.
I think it doesn't look like it.
Huh?
No. No. I'm not sure. I'm not sure what it's no. I'm not sure what it's referring to. Maybe we can find that out.
I'll be right back.
Yep. Maybe we can find that out later.
I just put, like it said on page or footnote 1, the citations to the record on appeal appear with the document number before the colon and the page number after. Citations to different documents in the record are separated by semicolons. Mr. Avery shall cite to the currently filed separate appendix as at. So I don't know what, I know she explains somewhere, maybe it was back in the beginning, with a different brief where, okay, this is, refers to this and that refers to that and stuff like that. So, but it was something long because page 1132.
Yes, that's a pretty lengthy document. What else is Duke saying here? Maybe she got busted for having Strider brief. I hope not. I hope he's not involved. Again, Duke says, again, probably just a mistake, which isn't great timing considering she had just gotten done calling out of the mistake by Brian. No, I mean, it could have been just a simple typo. It's possible. I tend to think that's what it is, but we don't know that. But again, yeah. But again, to me, she really went after Judge Angie, and what she considers multiple mistakes in her reply brief. And there's Doc.
Hey, how's it going, guys?
What do you think?
Oh, fantastic read by Susan.
Wasn't it?
Thank you, Doc.
Yeah, no, that was awesome. Pretty similar to what she had before. She made it briefer. She highlighted all the important points, and I really think it's a great document, something for the state to now properly consider. I think she made all her points, very, very strong points, and I think it really highlights the frustration of how far someone has to go in order to prove or to actually get the case reheard again. I know that there's a lot of strong resistance in the community getting Kathleen Zellner in front of a judge, but I do believe that she has presented a very strong case, made some good, strong legal arguments, and to be honest, I think it's time now to present it in front of a judge and sort out this mess once and for all.
I don't know how you can't.
I agree with you, Jack. It's so plain. I mean, they have followed everything the law says they need to establish in order to get an evidentiary hearing.
At minimum.
Any subject. Yeah, absolutely. So I can't see how the appellate court can possibly go around this and agree with the Supreme Court.
Yeah, I agree. That's what I'm saying. She's narrowed it down pretty tightly. I mean, of course, not being a lawyer, it seems that Kathleen, in her opinion, in these various cases that she cited, that Judge Angie cited, and the incorrect way she did it, seemed pretty strong to me. But again, I'm not a lawyer. It's hard for me to know if I'm right. She sounds correct because of the reading, the quotes that she provided. So, any takers on how long it's going to take the Court of Appeals to reply?
Well, we have to first wait for the state to reply.
Well, yeah, that, but
due March 22nd or something like that.
40 days? Is that what they get?
They'll probably file an extension. And then, who knows? It'll be a while, I imagine.
Yeah, it's also interesting that I found, which I thought was just a really huge blunder that Judge Angie did, was including anything from Brendan. And she did. And getting these other case facts incorrect. I mean, they're just wrong.
Right? Yep. The bones were in Avery's burn barrel.
Yeah, right. Duke says 4 years.
No.
It better not be. No, I don't think it'd be that long. I would say, I'm gonna say 8 months after the state replies.
Oh, good Lord! You think? Oh,
It shouldn't be, but I mean, I don't know their caseload. You know, I'm just basing that kind of on previous.
I remember Tracy kind of citing what's kind of normal for that, but I don't remember what it was.
It's less than. I think it's less than 8. I think it's more like 90 to 120 days is the norm. I think.
Yeah, it seemed like it was sooner like that to me.
I mean, for me personally, I think the way Kathleen Zellner packaged this was actually very strategic and very clever. It doesn't necessarily mean that Bobby Dassey had murdered Teresa Halbach at all. I think the way she presented this was, hey, look, Judge, this is what we've got. I've played by your rules. I did exactly what Judge Angie told me I needed to do to satisfy all the Denny prongs. If Tom Sawinski's observations are indeed true, now I'm not saying that they are, but if his observations are indeed true, then this is potentially very, very damaging, especially for Bobby. Now, could it have simply mean a misidentification by Tom Sawinski? That's entirely possible. But the way Kathleen Zellner presented it, she was very, very clever, strategic. If you notice, guys, she left law enforcement almost completely out of it in terms of any forensic evidence fudging or tampering, apart potentially from the groin swabs. But she had to come back by saying, hey, my client's toothbrush was missing. Now, it just so happens that a toothbrush would be a very rich source of DNA, because when you brush your teeth, your bristles of your toothbrush, they scrape your gum linings and the inside of your cheek, right? Which means that your toothbrush is actually going to be full of epithelial cells. And there's been many cases in which natural disasters have occurred, earthquakes, fires, in which they're trying to obtain a DNA standard from a victim or victims. And guess what they obtain from the family? Their toothbrush.
That's right.
And they're prepared DNA from the toothbrush in order to get a DNA standard. So the concept that you can't extract DNA from a toothbrush is completely false. It's a rich source of DNA. Now, did this happen in this case? Not necessarily. That's not the point. I think what Kathleen Zellner is doing, and very strategic, she's covering all angles, whether they are reasonable or preposterous, right? So she's basically saying, I played by your rules. I'm presenting my Denny suspect. Let me present it in a court of law. We'll argue it any way that you want. Guys, what do you think? I think that's the way she packaged it. Very safe, playing by the rules established by the state. And when you think about it, it is a very, very strong case if everything holds up well. And now we mustn't forget, potentially she could subpoena both Senglaw and also John LeGuern, the propane tank driver, because he may be an important eyewitness who may have just seen Teresa Halbach drive out of the Avery salvage yard. Not saying that that occurred, but it's something that now can be examined further in front of a judge. I tell you what, it's a pretty compelling case, none of which was really established or examined back in 2007 during Stephen Avery's trial.
Or at least that her vehicle left the property. He couldn't see the driver, but
That's
He
100%
saw the
correct.
vehicle. Yeah.
That's 100% correct. So it provides a potential avenue to back up what Stephen said.
Yeah.
And another thing, Lurquin did not say he saw Bobby's car, right?
No. No.
Correct. No one had seen a Blazer drive out, which is very, very interesting in itself. And again, we're going to expand upon that in the next reading with the crew. But it's incredible the way Kathleen Zellner has packaged this. It's going to be very hard for a judge to reject this outright. Rightly or wrongly, I believe that there are elements here that need to be sorted out one way or another.
I really don't understand how the Court of Appeal, I mean, I guess they can, reject it, but I'm not sure how they will excuse it and what next step that Kathleen might take, if she might take it to the next level, which would be the Supreme Court. I guess that's the next step. If the Court of Appeal says no, denies it.
The Wisconsin Supreme Court, yeah.
Yeah. State, yeah. I just don't know. I just don't understand how they can not have a hearing to sort these issues out because of how the law is written. The Sawinski.
Yes. They have to put
affidavit.
Sawinski, Romlow,
Baresh,
all those people on the stand and dive into it and find out.
Hammer it out. That's right. Hammer it out. Because an affidavit is considered as true until you prove otherwise. Just discredit it.
Yep.
And I mean, Anthony Hills made the comment that there was another eyewitness, also Robert Fabian, saw the RAV4 allegedly at the turnaround as well. So, without any of the hoo-ha and hysteria surrounding this case, there's a lot of anecdotal evidence that multiple independent eyewitnesses have seen a vehicle looking like Teresa's RAV4 off the Avery salvage yard, right? Yep. And these are multiple independent eyewitnesses that did not collude together, did not collude their stories. Tom Sawinski did phone in on November the 6th. We do not know what he said to Segenglob, right? We don't know that. But he did phone in on November the 6th. So hence it was close in time to when the actual RAV4 was discovered on the property. John Le Guin, the propane tank driver, he never phoned law enforcement to say, hey, look, I think I saw a vehicle that looked like the victim's vehicle. It was Tom Fassbender that went out to search him. So quite clearly, John, the propane tank driver, is not a glory seeker. He's not an attention seeker, right? So the question is, when you mount all of this anecdotal evidence, jeepers, it's starting to add all up. With Tom Sawinski, why he's damaging is because prior to when Pam of God found the RAV, according to Tom, he saw two people, two males, pushing what appeared to be the victim's vehicle on Avery Road. So it all gels together. The anecdotal evidence suggests during the flyover, no one spotted the vehicle at the pit. No one saw it. Earl, Robert, they were down there. Remember, sighting in their weapons, in their golf cart. They never saw
rabbits.
Hunting rabbits. They never saw it. So it all adds up and gels with the vehicle being placed on the property. I am not suggesting it was Bobby, but when you distill it down, guys, should anybody have had their hands on the victim's vehicle?
Hell no.
Hours of Saturday morning? That's exactly what Kathleen Zellner is trying to push forward in her narrative. Hey, I'm saying it's Bobby because of all the Denny prongs that I must satisfy. Judge, let's discuss this. Let's work it out who could it have been? Guys, is that correct? That's what
Yeah.
Kathleen wants. She just wants a hearing. Hey, look, guys, let's talk about this. Let's sort it out. Is there a simple explanation for Bobby? Can we clear Bobby? I think that's what she's asking.
Well,
We also have the old guy at Jambo Creek Road that saw them going
Yes.
into the pit. The
That's
Rav
correct.
and the white
Siebert.
Siebert. Yeah.
Correct.
Yeah.
And
And
of course,
we don't know what we don't know precisely what Sowinski said to Singlub, and we certainly don't know what Singlub reported while he was there on the Avery property to his superiors. We don't know. No report.
correct. And for Kathleen Zellner, she really has to present Bobby as a potential Denny. Why? Because you've got to satisfy all the Denny prongs. And so when Angie's coming up with all these counter arguments, they can be easily attacked. And some of the things that she said were preposterous. Because Tom Sowinski never saw Bobby holding up her keys and electronics, you can now dismiss him as a Denny because he didn't see those items. That's crazy.
It was ridiculous.
Well, Dukes makes
Ridiculous
an
argument.
interesting point here. After Sowinski called in, I can only imagine he said he was a newspaper carrier to Singlub, and I was there at X next time, and this is what I observed. Whether he named anybody or not, it doesn't matter. And they didn't pursue the newspaper driver.
Well,
And you have the ex-girlfriend to back him up.
That's right.
As well, in an affidavit. So that just adds to it.
Correct. And I also echo with what Duke has just said. Because remember what they did. They canvassed everyone in the area. They took the names down of anybody who was in the vicinity, and they spoke to the mailman. What they didn't do was to determine whether Stephen had received any newspapers. And if that's the case, it would have led directly to Tom Sowinski back in 2005.
Hell, the newspaper was in his trailer.
Correct.
Sunday, the day before.
Anyone that reads the DCI reports will see that the DCI canvassed the hell out of the area, and people that had came in and bought whatever parts and so forth, used parts.
What day was it, Doc?
The newspaper. I think Duke found that, or someone assisting was on the 30th.
Yeah.
No, I mean when they asked the neighbor up on the corner when their paper was delivered. What day did they ask him that?
Let me just see.
What was his name? Springs Tube?
Spring Tube. Yeah. Yep. We've actually got the DCI report on our website, but I'll see if I could find it in my document.
Yeah, I saw that on your Reading with the Crew the other day.
Yeah. It was Spring Tube. I'll see if I can find that. So they most definitely did investigations and canvassing of the entire area, including what they saw. But as a consequence of that, that's how I got to find out that there was another propane tank driver, Klein, on the other side of Highway 147. Mm-hmm. I didn't even realize that they canvassed him. They spoke with Dubeck, and he was the mail delivery. I'll see if I could find Spring Tube. Let's have a look.
I'm just wondering if that was after.
They spoke to Spring Tube on the 6th of November, 2005 at 11 o'clock. Same day. Same day.
So that was before he actually called in, because he called in later.
That is correct.
Or something.
That is correct. Yep, that is correct. So it's the same day that they talked to Spring Tube, and they asked him about. He talked about the delivery of the Herald Times.
You
I can
wonder
tell you
why
that-
they would ask Springtube that and why they wouldn't go directly to the delivery person, you know?
Well, you know, Susan, what is remarkable is that evening, Tom Sawinski, who delivers the newspaper, rings up. And it
Yeah.
stopped there. It didn't go any further.
Yeah.
I
far
can't
as we know.
explain. Yeah, as far as we know, correct.
Yeah, I can tell you for a morning paper to be delivered that late in the morning, that doesn't, something's not gelling with that.
Unless there was an afternoon edition. I don't know.
Well,
Yeah.
if it was afternoon edition, it probably wouldn't even be delivered until,
Afternoon.
probably midday. I mean,
Yeah.
I'm talking
Yeah,
about the
'cause
person
you
that
have
brings
to
it to
print
the new.
right? Right.
Yeah, it wouldn't get delivered by the guys that go around and deliver all the papers to the newspaper carriers until. I mean,
We
it
know.
just depends on the
We
region.
all know. We all know that the newspaper is delivered when it's still dark outside. I don't
Oh
care
yeah, the
where
morning
you are.
paper. Oh
Yeah.
yeah,
Yeah.
morning paper. Oh yeah.
You have it with your coffee.
Yep. Jay said that told me he messaged me and said that his parking was up and he's not going to drive and talk at the same time, so he wanted to say goodbye to everyone.
Awesome.
Bye, Judy. Drive
So,
careful.
absolutely. So anyway, in the final analysis, I think again, I think Kathleen has delivered a strong message of all of what she considers are mistakes by Judge Angie. And the expectation is that the Court of Appeals will reverse it and force a hearing or a new trial or some other remedy to move the case forward.
Yeah. The way I see it, guys, I unfortunately see it as a bit of a game. In terms of you've got to play by the rules, by the rules of the court. You've got to present a strong case, which doesn't immediately get thrown into the bin, and you've got to play by their rules. I believe that Kathleen Zellner has been very, very cautious, especially pointing a finger at any law enforcement officer. And you notice she didn't even mention possible contamination in the crime lab of Ida Maffel. She was very, very cautious. So she's basically saying, all right, if it was Bobby Dassey in possession of Teresa's RAV4, then he framed his uncle. How did he do it? Well, because he was in possession of the vehicle, because he was in possession of Teresa Horbach's body, he had access to this, he had access to that. Whether that's preposterous or completely ridiculous, hey, her aim is to argue that in front of a judge. And wouldn't it be remarkable if the judge goes, don't you think that's something that someone with specialized skills could do? You know what I mean? Like, okay, does this lead to potentially anybody else being involved? So the important thing for Zellner is to introduce an element of doubt.
That's right. And what would the jury have? What could a jury have taken away if the Sawinski material had been available in 2005, like it should have been?
That is correct. That is correct. So their argument is, would all of this material have changed significantly the outcome? I do believe that if they had the Valey CD, right, plus Tom Sawinski, Baresh, and all the other individuals coming forward to say, look, I did see two gentlemen. One of them appeared to look like Bobby Dassey, push the victim's vehicle. And then they presented the other eyewitnesses. They said, yeah, look, I think I did see the victim's vehicle on close to Highway 147. Jeepers, wasn't that the direction that Bobby said he went hunting? So all of this leads to an element of doubt. That's what Kathleen Zellner is after, in my opinion.
I have to agree.
Absolutely.
And yeah, and when you factor in now John Le Guin and his potential sighting, now he never said he saw Teresa Horbach or anybody in the driver's seat. He never said I saw a Toyota RAV4, but something tweaked in him when he saw the material on TV, because he told his friends 5 days later and goes, "Jeepers, that the car that I saw looked a bit like that." And he said it was a green mid-sized SUV. To me, this now starts to become all accumulative, because I'm only speculating. If he didn't turn back his clock, it's in the exact time frame that both Bobby leaves and when Stephen said he saw Teresa turn left on Highway 147. He's bang smack in that time frame.
Yeah, and I think we discussed it the other day, talking about for him being delivering propane. I mean, I guess he's on somewhat of a schedule, but it's not like punching in and out at at the factory, and you got to run a machine or the line shuts down. It's not like that
Right.
for him.
I would guess that, if somebody has ordered propane, they say, well, we'll be there between 10 and 2 or 10
They
and
probably
noon,
say
or,
we'll be out there on the 5th.
right.
I think because my mom and
Maybe
dad
give
had
them some kind of time frame like, the cable company does, or, any service people that are coming out. They usually give you a time frame, not
which is around about a couple of hours, right? A couple of hours.
Not a specific time. So
No.
he wouldn't have been on that kind of schedule.
I'm trying to remember. My mom and dad had a propane tank back in the 90s and early in the 2000s. And I know that guy would come. I can't remember if he would give them a time frame or just, I'll be out there sometime today.
Yeah.
Or maybe, I think it was more like he would say, I'll be out there on such and such day in the morning or the afternoon, but he didn't necessarily give a time. But they're retired, so it wasn't no big deal.
The other propane driver made the comment that they weren't delivering a lot of propane at that time. Like, it wasn't a real busy time.
Correct.
So, Sawinski could have very well been earlier than he normally is to refill his tank, to top it off.
Le Guin.
Yeah. Yeah. Lurkwin. Yeah. And he could have gotten there earlier. His clock could have been right, and he could have gotten there earlier because he wasn't all that busy that day.
Correct. And he said that he was there for about 30 minutes.
30 minutes, yeah.
Right, 30 minutes. And when you think about it, there's no one there at the bulk plant filling station. You roll up when you roll up. There's no one there manning the propane tanks to say, Le Guin arrived at this. No. He said, at the end of the day, I go there, I fill up, I go home, I'm ready for the next day. And no one would have said to Le Guin, "Jeepers, mate, why are you delivering propane to my house 1 hour earlier?" They would have said, "Thank you, Mr. Le Guin, for delivering the propane," right? Yeah. That's it. Correct.
And, if he normally was there between 3:30 and 4, that doesn't mean he always was.
Correct. Yeah.
My point is he could have been an hour earlier if he wasn't all that busy.
Correct. He said, he basically said, look, at the end of the day, I fill up my tank and I go away, go home. But I think the cryptic clue is the fact that he missed the bus twice.
Yeah.
Bus entering and bus leaving. That to me is what tips it in the favor that he was actually there earlier.
Mm-hmm. Me too, because I just don't think he would have missed it both times. Maybe once, because I'm guessing, just thinking about it, I was thinking about this the other night. When he pulls up, I'm guessing that the mechanism is locked, and he has to unlock it, and there's probably a
Correct.
process to do that. It's not just
Correct.
like a simple, I'm going to take a lock off of like a padlock. There's probably more to it to keep thieving from happening.
Yeah.
Yes. Yep.
So
Correct.
it's probably going to take him, a couple of minutes to deal with that.
Yeah.
I just
hooked
I just
up
can't
and-
see. I just can't see him missing the school bus 2 times, and he would have. I'm sure that Buckner probably drops off probably within a 5-minute time span every day.
Yeah.
My guess.
Yep.
Mhm.
That I went through the testimony, all of them that mentioned the bus, and one thing that was certain, that the bus was on time between 3:40 and 3:45 daily. It was something that was consistent.
Paul Ward asked, "Do you think they cut Bobby a deal? Say on the stand what we want, and we bury the computer contents." We just have no way of
Possible.
knowing that. It's possible, I guess, but we have no
Possible.
way of knowing that. Hey, there's my neighbor, True Crime Fangirl. Hey, neighbor. Spring Steve, what did she say? Spring Steve's son lived near Cuss Road, right? The road off Cuss Road. I think that's right. I never really studied too much about them.
Yeah,
I
he
think we
was
did
pretty
too.
close. He was pretty close.
I know that there was the Spring Steves had a house real close there to the Averys, and I know that house got tore down.
His address.
Up by the sign, by the Avery Road sign, up there on that corner.
That red house that you see in Mam, it's not there anymore, I think.
Yeah.
Yeah.
Yeah. He actually lived at 3215 South on Highway 147, Two Rivers, Wisconsin.
So it was just right around the corner, basically.
Yeah.
I also learned at one time, interesting fact that I didn't know, that Chuck had a grandchild that lived on Cuss Road. I'm not sure if that was with the Springs too, but it was with the family over there that they were foster parents for his daughter's child.
Oh, Shannon's child? Shannon's child?
I assume Shannon's. Does he only have Shannon and what's her name?
Carla.
Carla. Thank you,
Could have been
Sherry.
Carla. Yeah,
Not
I don't
Carla's
know their
child. I think it was the other daughters.
Shannon.
Mhm.
Yeah, I'm not familiar enough with the family history. Other than knowing just who a few of the sons and daughters are. I'm not sure about the other though.
We
Yeah.
know she had some issues, so it's
She
it was more likely to
had a
be
bad
hers.
drug problem, and yeah, I thought that was interesting though. They lived on Cuss Road.
Carol says Paul Ward has crossed my mind many times. Yeah, we just don't know, what went on. Other than we know that many people were highly pressured. I mean, even Barb is. I mean, of course, she's kind of one layer removed, but she's even come on and said that how much pressure that people were under. Kayla said it. What Fassbender and Uyghur did to her, they wouldn't believe her, and they took and twisted everything. Fallon did. He twisted everything in Brendan's trial. And what they did to Brendan, Jesus Christ, I mean.
Yeah.
So they weren't going to take anything but their story for an answer. And, we see that, that American Nightmare comes to mind right away, what that cop did.
Terrible.
Oh, yeah.
Yeah.
There's also a lot of talk on the telephones about how strongly Bobby was pressured by them.
Oh, yes. I got those recorded calls.
Among the family, yeah.
Yeah. Barb was talking to Stephen about what they had done to Bobby, how he was treated, just in talking to Dolores too, if I'm remembering correctly. I watched another interesting documentary the other night. Lover Soccer Killer. I don't know, it's on Netflix. It's a new one
Huh.
about this guy that got divorced and he starts dating, and he dates one, didn't work out. He starts dating this other one, and it kind of didn't really work out for as far as he was concerned. He starts dating this next one, and her name was Carrie, but the one that he had dated prior apparently had a fatal attraction. Jesus Christ, what this woman did! Oh my God, unreal. Now this is it's like an hour and a half documentary. It's definitely a good watch. And what a couple of
Thanks.
cops
I'll watch
did.
that.
Yeah, what a couple of cops did to catch her.
Mm.
They really went the extra mile. But yeah,
Well,
Doc, everyone, I think that I think the amount of pressure that they put on certain individuals, we probably will never know unless they're put on the stand and to talk about it. I don't know.
it'll be interesting, the state's response, see how they try and weasel out of this now again.
Yep. Correct.
Well,
Yeah, I think the reason, well, there are multiple reasons. The last thing Wisconsin wants on their record is to have an individual exonerated twice. That would be a massive disaster for the state, and the implications, it will just be horrendous. But at the end of the day, it is true. Everyone has a presumption to innocence, and that of course includes Bobby Dassey.
absolutely.
But I believe that there is enough material there gathered anecdotally and also directly that I believe that a judge should hear the case and take it on its merits. Take it from there.
Absolutely. Absolutely. I believe that Stephen should have a new trial with everything that has come to light before
Yeah.
and after.
Yeah, correct. And this is nothing that Stephen could have manufactured from his jail cell. This is all
Yeah.
occurring around him, and a lot of this material was actually very early on during the investigation, right when Stephen wasn't arrested. So you've got all these independent eyewitnesses bringing forward all this information, which is very interesting.
That's right. Yeah, there's been some talk on one of the Facebook groups about how Stephen is in control of this one Facebook group that's his. He can't control anything from prison. He can't. Sorry, it's just not possible. Now, he may have conversations with those administrators that are running it, certain things, but as far as him controlling it, I'm sorry, I'm not seeing it. But,
Yeah, for me, the problem with this case is that it's forever tainted. There is so much background noise and rubbish that you've got to remain focused on what are the important elements that a judge can consider and weigh the importance of. But again, because of all the hysteria, you saw what convicting a murderer did, right? How they focused on truthers, that they're all lunatics, they're part of a cult, that they had their amygdalas hijacked, and there was a huge focus on how much of a bad person Stephen was, rather than saying, all right, we're going to prove to you how this murder went down. We're going to show you precisely how this murder took place. They can't, because the reality is, Kratz, if he's honest, Fassbender, Wiegert, they don't know what went down. They don't know how this murder happened. It is the truth. They do not know how this murder happened or where it happened.
And it's a horribly documented case too. Horribly documented.
Correct.
Yeah.
Which really, well, you can say, well, that, if they're documented, it would help the defense. But if it was actually what they found, it would have bolstered the state's case. Photographic evidence. I mean, could be faked, but
Absolutely.
show me photographic evidence. Change my mind. And it's not there. I mean, there were even discussions not long ago about allegedly bones, and there's photographs of bones in the burn pit. There are no photographs of that.
Where are
I've
they?
told a lot.
Yeah,
Yeah, they would have been shown at trial if they
they
existed.
absolutely would have. They absolutely would have.
They would have been an exhibit, and we would have had them because we've got a bunch of the exhibits back in 2016, and we have definitely would have gotten them. They don't exist. If they had, Gratz would have shown them.
And if they do have them, they look like they were just dumped there.
Well, you have to understand that that's exactly what Earl said. The reason why he didn't document the crime scene was because he said it that had been obviously disturbed. And that comment is disturbing, pardon the pun. Because they are the very first people to have discovered the cremains in the burn pit, which means how could it possibly have been disturbed if they're the ones, if they are the co-discoverers of those cremains in the burn pit? No one could have disturbed them, but for Earl, who had his photographer with him, not to document the discovery of the bones, I think that's very telling in itself.
Well, and for him to outright tell Fassbender in the email that the scene had been disturbed. I'm not taking photographs of that. I'm not doing it.
Yeah, correct.
Probably the smartest move that Earl made in everything that he did.
Correct. And he was understandably very upset and pissed off.
Well, of course.
He was the last person to be called to everything. And remember how the detectives went in and did all the swabbing of inside Stephen's property, whereas Erdl and his team were just twiddling their thumbs because it was raining, right? They had a camera guy, they had all the equipment, that didn't use Erdl until much later.
Right, and on the 8th, they didn't call them for an hour and a half, and the only reason they called them was to get the sifting equipment over there.
Correct. Yep, correct.
If they'd had their own sifting equipment, I'm not even sure they would have been called.
Right.
No,
I don't know that, but
correct. And like Susan said, if those photographs showed that the cremains were actually dumped, that's not a good look, is it? That's not a good look. The state's hypothesis that Teresa Horbach was cremated in that burn pit as the primary burn location.
But we pretty much know that's not the case because there are photos prior to the 8th of the burn pit. They're not close-ups, but we can see there's not a pile of bones.
That's right.
Sitting there.
Correct.
They're not there. It doesn't exist.
Correct. And as Jack 61 eloquently pointed out months ago, Trooper Reese was standing right next to the burn pit, literally right next to the burn pit. He never made any comment about a large, aggressive German Shepherd or, oh my God, there's a pile of bones, literally feet in front of me. Never said a word.
He could have taken 1 or 2 steps left and been standing in the pit.
In the pit, correct.
That's how close he was. You can see it from one of those photographs he took.
Yep. And Bear actually was on the other side of him, right back towards the garage. Did not approach him. That's remarkable when you think about it. And what
he was within the length of his chain. Yeah.
Within the length of the chain. Correct.
Yeah.
Yeah.
And, sorry, Jackson.
I was just going to say, speaking of, wanting to get a dog expert on, anything going on there, Doc? Soon?
Well, I've got some interesting news. I've been speaking to a gentleman. I can't reveal his name because he's in law enforcement. He's a professional canine dog handler. He does cases. And he actually has agreed to come on one of our podcasts, open mic, whatever you want to call it. And he's got a lot of interest in the case. I've presented him with some material. He's gone away. He's independently read it himself. And it'll be awesome. He wants to come on and present some material about how the canines work, including both human remains detection and also a bloodhounds as well, scent dogs. It'll be awesome if we can get them on a podcast very soon. And this is a professional canine dog handler, works in law enforcement, does cases. I think getting the information straight from him will be awesome.
You know what's
Agreed.
interesting to me? What's interesting to me, and I've thought about this. Maybe others have too, but thinking about what was presented in CAM by Officer Sarah Fausk and her dog Loof wasn't there until the 7th, which this is allegedly 7 days after Teresa arrived. And given the scent of Teresa inside the sneaker, my question, I guess, is, or maybe my bigger concern is, why wasn't one of the other dogs from Great Lakes given Teresa scent on the 5th or even the 6th? I don't understand that.
Good question.
Why did they wait?
Yeah, that I have an awful feeling they were looking for a body, right? They were looking for a body, and hence the preponderance of human remains detection dogs. And Kratz, in his book, even said that once Brutus had given the alert behind Teresa's RAV4, they believed in their mind that it was a homicide. They were looking for a body. Now, quite clearly, a scent dog is going to look for live scent, but the Loof never found a body. Loof never found a scent source, right?
Well, I know that live scent dog. I mean, I know the cadaver dogs arrived first, but live scent dogs did arrive after the evening of the 5th. So they had them available. I just don't.
And what they're looking for Teresa alive. And if
Yes.
they don't find Teresa alive, you can't use any of the information that they've given you.
Well,
they didn't find a body. Correct. None of the scent dogs did, of course.
a scent dog. Hopefully, this the professional is going to call and talk to us. But my understanding is a live scent dog seeks the source. That's what they're after.
Live person.
Yes, and this gentleman, he's very, very judicious. He actually did. He also looked at the 3D map of the Avery salvage yard, including elevations, and he also did a simulation of the distribution of scent. Oh my God, this guy is incredibly thorough. And he looked at the weather conditions, and only 2 out of 11 days, the wind was blowing in the direction of the western berm. All the other occasions, the wind was blowing away from the western berm. So the majority of the scent, if there was any scent, was being blown away from the western berm.
Well,
and this guy's done all the 3D analysis, and remarkable.
But this claim of Teresa being in that burn pit, burning, and wafting these live scent cells or cells of some type, I would imagine they had to be damaged, being in that hot of a fire, going up in the air from the heat, got that, and wafting around in the wind, surviving to be detected by Loof. I just have such confusion about that. Hopefully you can clear that up.
I won't repeat what he said.
Sense.
I won't repeat what he said. It wasn't good. It wasn't good.
I've got a feeling I know what he's going to say, but okay, that's fair enough.
It is not logical. Period.
No, it's not. But and even 7 days later, just in talking with Jeff when he was around, a few months ago, this scent of Teresa lasting beyond, about 72 hours. It rained like hell on the afternoon of the 5th, twice, right, Doc? And it rained twice on the 5th?
Correct. Yes, I checked the weather conditions. I gave a copy to Susan as well. We looked at the weather conditions and things like that. Yeah, there was on the night where they had the RAV, as you've seen from the crime scene pictures, it bucketed down. There was a big thunderstorm that night. And this gentleman said that weather conditions, especially rain, have a drastic effect on scent and things like that. And that's why
Right.
he did a 3D map, a contour map of the entire area. So, yeah, this guy
The terrain.
the terrain. He did a terrain map. Apparently, there are program sites that you can go to, put
Yeah.
in a location, and it'll do a 3D map for you. And hopefully, we can get this gentleman in and just get him to explain how these dogs work.
Oh, I'd love to hear
Yeah.
the process.
That would be awesome. Yeah.
It would. Yeah,
Incredible.
Really looking forward to it.
Yeah.
Okay. Well, unless anybody has anything else, we've been here 2.5 hours. I really like this brief. I think it's, again, laser focused. She went after Judge Angie with a hatchet because, in her opinion, she got so much wrong. And I can't disagree with her logic. Maybe I am wrong. I'm not a lawyer, but as it stands right now, I can't. And it also, again, brings in the question why Judge Angie left the case after this many years. Why would she just walk away? It's like,
Sure
you've been here this long. Yeah. So looking forward to the state's reply and how Lisa Comfer is going to try to explain this. Bethany, I'm sorry.
Too.
Bethany just got off work.
Well, thank goodness it's recorded, Bethany.
That's right. Bethany, you can start at the beginning. Susan did a fantastic job. She read the entire 45 pages, so you can go back and listen to it. It's real. I mean, I think it's really, other than a couple of, I think, typos, it's really well done. So,
yeah.
I just want to address this question. Anthony Hill's got a cue there. Was there more blood in the back than in the front? I believe so. Was there not?
In the back of the RAV?
Yeah.
I guess that's what.
Oh, most definitely. In terms of volume, there was much more of Teresa Horbach's blood compared to Stevens. It's interesting that Kathleen Zellner said between 1 or 2 mils. There was far less than that. I worked it out on the bare minimum. We're talking about 300 microliters. That's about 0.3 of a mil. That's a very small volume of blood that belongs to Stephen. In terms of volume, I don't know how much volume of blood there was of Teresa's, but there's definitely many, many more drops and smears than Stephen and Stephen's blood. Correct.
Yeah. I mean, it's minuscule on the cargo door, but there's still some there. It's clearly present.
Correct.
And to me, she did point that out too a couple of times in her brief about the RAV4 being the murder scene. I believe that. Right, but I don't know if she was necessarily killed behind the RAV, but I definitely feel strongly she was disabled right there inside that.
Yes.
I mean, the door, it swings open, at least to a 90 from its resting position, closed position, I should say. So if she was back there getting something out, maybe rearranging, we don't know. BAP. We just don't know.
Yeah.
Right. But anyway.
The blood tells the story.
It does. The blood definitely, and also the dogs. Don't forget the dogs.
Right.
Dogs have no bias.
No.
They don't give a damn. All right. Everyone out there, I actually had intended to do something different tomorrow night, but I don't know if Susan's available. Are you going to bunk buck tomorrow, Susan?
Tomorrow's Wednesday. I don't know yet, Jack.
Okay. Well, we'll loosely plan on tomorrow, but maybe Thursday, since Rhonda's not going to do a live this week, and finish up the last deposition that we started on, Dvorak.
Yeah. Okay.
I'd like to get that finished before Sunday. If everyone's available. If they're not, then it's fine. That's okay too. It's not going anywhere.
I'm available tomorrow. but not
What about
Thursday.
Thursday?
No, I already made plans for Thursday because we weren't doing that. So going to a
understand.
dinner party.
Dinner
Pajama
party.
It's actually
Oh.
just a gathering of 11 people, and it's called Soup and Conversation. And everyone only has one conversation all night. Everyone is
Oh.
always engaged in one singular conversation. So,
Wow. I hope it's interesting.
well, it could be, but I seriously doubt that's going to happen. So,
I was
anyway,
gonna say for
You
for
could
several
talk about
hours. This
the corruption in Oklahoma for hours and hours.
oh shit, that's stressful.
That's not a conversation. That's a convention.
Oh Lord, it's all the people are cool though. So
Sounds like fun,
yeah. Anyway,
but not in your pajamas.
no, not in my pajamas. No.
Okay.
Thank you, Crown
Not in
Vault.
yours.
Thank you for the comment and support. Appreciate it. We all appreciate it.
We do.
Yeah. Anyway, unless somebody's got something to add, I think it's time we wrap up and get out. I actually delayed dinner tonight, so I'm ready to eat.
Yeah, thanks for jumping in, Jack. Really
Oh,
appreciate
no problem.
you.
No.
Fantastic.
Yeah, I mean, when Susan texted me, I actually had just grabbed the PDF file, but I was in the middle of doing something else. I was like, wow, this is early. It really shook me, and I already had something else going on. I couldn't jump in immediately or even by 5 Central, so apologies for being late. But
it was pretty darn fast.
yeah, it was.
Yeah, good job. Thank you.
Yeah, absolutely. All right, guys. Well, with that said, I'm going to pop this up on the screen, make her full screen, and just say we really appreciate everyone joining us. Like, share, subscribe if you wish. We appreciate that too. And without you, we wouldn't be doing it. So with that said, I'm going to say this has been a File Play production.